Hi, everyone. Good morning. Welcome to this webinar. We'll give a few minutes as a few more people find their way in the room. Good morning. Morning, Sinead. Great. So while we wait, let's do a quick weather check. Always a safe topic in Ireland, right? So pop in the chat where you're tuning from and what's the weather outside for you. And if you can hear me loud and clear. For me, so I'm based in the south of France. It is a sunny 16 degrees out there. It feels like fall already, but still the weather is treating us really well here. Hi, Linda from Dublin. Little gloomy. Oh, Kevin, very wet. Grey in Wexford. Good morning, everyone. Wet but warm. Soft day here in Cork. Obviously, Cork always have the best weather. Kildare, Tipperary, coming from everywhere. Cork again, Sligo. Morning, everyone. Lovely stuff. Great. So, very warm welcome to you all today for this webinar on employment law changes. And thanks a lot for making the time to joining us, and especially with this gloomy weather outside. I'm Marina, Marketing and Brand Manager at Great Place to Work, and I'll be your host for the session today. So if you have any questions, feel free to pop them. You have a Q&A function, you have the chat function as well. We'll try to assist as many questions as we can. We also have a Q&A session. We'll try to keep it to 10, 15 minutes at the end to really assess all your questions. So please feel free to use these tools. A couple of quick updates before we dive in from Great Place to Work. So the first one is that if you'd like to be recognized as one of the best workplaces for women in 2026, it's actually time to register with us and to launch your survey by November 10th. The survey slots are being filled out really quickly again this year, so don't leave it too late. We'll pop a little link in for you in the chat so you can book a call with one of our colleagues. And if you're already a Great Place to Work client and involved with us with your survey booked, no action is needed. You're already considered for these recognitions. The second update is our Employer Branding Summit. The tickets are live for the 7th edition of the Employer Branding Summit. It's happening this year at the Windmill Quarter in Dublin. It's always a great day, full of insights from brilliant speakers, insights on talent attraction, talent retention, and plenty of coffee and lunch. So again, we'll pop a link in the chat for you to be able to register for that. It's always a great opportunity as well to mingle with other Great Place to Work people. So we'd love to see you there. Great. So for today's session, we're delighted to be joined by Bláthnaid Evans. She's partner and head of employment and corporate immigration at Ogier. She'll be taking us through the latest update on employment law and what they mean for you today. I know this is kind of our yearly appointment where we try to cover for you as much as you need for the year ahead regarding this topic. So hopefully today will help you in that regard. So again, during the webinar, feel free to pop your question in the Q&A, even if we only assess them at the end, feel free to pop these questions in the Q&A so that gets us prepped to assess them at the end, and we'll tackle as many as we can. And slides will be shared as well in the follow-up email along with the recording. So no need to scribble notes frantically. You'll have all of that at the end of the session. So now a little bit about our guest. Bláthnaid has a wealth of experience across all areas of employment law, from contracts and policies to disputes, investigations, and big commercial transactions. She regularly represents clients before the WRC, Labour Court, and High Court, and was even named Labour and Employment Lawyer of the Year in 2023. She's known for her practical approach and advice, and you're in good hands today with Bláthnaid to cover this topic. Welcome, Bláthnaid.
Hi, Marina. Thanks very much for having me this morning.
Fantastic. So before we dive in, we'll launch a quick poll there on the screen, and we'd love to know how familiar you are with this recent changes in employment law. So we'll take a quick poll there. So how often do you update your HR policies, and do you feel prepared for upcoming changes in employment law? We'll give a few seconds so you can fill in the poll there. So how often do you update your HR policies? Annually, every 2-3 years, only when required or rarely? Second question, do you feel prepared for upcoming changes in employment law? Yes, no, not sure. Great. Now on to the results. It looks like this webinar is going to be very valuable for everyone today. So Bláthnaid, you have an important mission today, is bringing everyone up to speed on the latest and upcoming changes in HR law. So over to you.
Thanks very much. So I'm just going to share my screen. Hope this works. And checking, you can see that okay?
Yeah, all good, full screen.
Perfect. Okay. Yeah, great. Okay, so welcome everyone, and thank you very much for joining this morning. So my task today is to sort of take you through the upcoming changes in legislation, and I'm also going to finish the talk with just talking with you about a couple of recent cases that have happened this year that are quite relevant, and sort of give some practical tips, particularly with changes in law, etc., that has happened. And then I'm going to sort of conclude with the annual WRC report, which can always be useful in terms of trends that have sort of happened in the last year. This is a bit of a whistle-stop tour. I'm not going into a lot of detail in any of these topics, but I'm hopefully covering as much as I can that is going to be useful for everyone today. As Maureen has said, please pop your questions in the question box. I will try and deal with all of them if I can today, but if not, I will promise to come back to you as a follow-up to the webinar today. So as I said, today I'm going to talk to you about the minimum wage, the sectoral employment order that came in for the construction sector, pension auto-enrolment, and pay transparency directive, which is probably the biggest hot topics at the moment. I will talk very briefly about the EU AI Act, gender pay gap, the maternity protection, employment equality and preservation records, as I said, employment case law developments, and the WRC report. Okay, so we'll get started. So we'll get started with the easy ones first, and then we'll get into the more complex ones. So as happens every year, the national minimum wage has increased. It was £12.70, and it's now gone up to £13.50. The budget next week will most likely announce another potential increase for January next year. I think the hint is that it's going to go up to €14.15 per hour, but look, we'll have to just wait and see what that is. I have set out a table here in my slides. As you'll all be aware that the €13.50 per hour applies for people that are aged 20 years over, but if you do have any sort of younger employees, there is a slightly reduced rate. Next of all, then again, very briefly, sectoral employment order, which came in for the construction sector. This only came in whilst this 2024. It came in force on the 1st of August 2025. And this will basically see, it has seen a 3.4% increase in minimum pay for certain workers for this year, which will then go up a further 3.2% from August of next year. And we've also seen a slight increase in pension sick pay benefits. Okay, so pension auto-enrolment, hot topic. Thought it was going to come in earlier, but it's now going to come in on the 1st of January, and it is definitely coming in. There's no doubt about that. I saw an update today that the National Automatic Enrolment Authority will be getting in touch with employers in January to start getting employers on the roll for this. And so you will need to have done your homework to sort of have the assessment of your workers in place, where they are in terms of, do you have a pension scheme? And I suppose what's important about this in terms of the applicability for it, as with most of, so you might not have a pension scheme, or you might have a PRSA, and then employees, as is their right, have elected for whatever reason to not join the scheme. And it's important to say that if an employee is elected not to join the scheme, they will automatically be enrolled on the scheme. So it's very important. They do have the option to opt out after 6 months, but they will automatically be enrolled on the scheme. And on the next slide, I'll just talk you through the incremental contributions for this. But it is said that so if an employee decides to opt out after the 6 months, they will be refunded the employee contributions, but the employer contributions will stay in the fund, in the pension fund. So that will be picked up at whatever stage again they decide to join. And as each increase comes in, right, which is as the scheme develops, the employee will have the right to opt out again as per the scheme, with that being phased out at the maximum increase of 6%, which is due to come in, I think, when it's sort of 10 years. But time will tell, will we get to that level? You have to use the comparison, for example, of sick pay, which has stopped. We sort of saw the incremental increases of that, and the increase of that has paused.
Yeah.
So very important to be aware. Make sure, I suppose my tips on it would be, make sure you've done the assessment to see. Sometimes it's just worthwhile. It can be complicated to have dual schemes going on, right? But it might depend on your workforce whether that works for you, okay? And it's not a one size fits all. Some clients would come to me and I would say, let's try and get them all on the scheme that you have, because that makes sense. But equally, you may be in retail, you may have, students there, that it doesn't necessarily make sense to put them on the more expensive scheme, but instead to enroll them in the government scheme for that specific category of workers. And that's fine. It's whatever works for your business, but you just have to make sure that you are compliant, obviously, with the legislation.
Yeah,
So
and we've actually launched a quick poll there to ask people if they have a pension arrangement in place for 1st of January 2026, and in the call, 58% do have it. 11% don't have it at the moment, and 31% are working on it at the moment. So you're in the right place to collect all the information you need to do so.
Well, it's very impressive stats, actually, because I've talked with some other providers, and they've heard that there's probably more in the no percentage there. So the fact that we've sort of nearly 60% yes, and a good 30% that in the process of setting up
Yeah,
is very positive for sure.
that's very good.
So
So people in this call are quite advanced. That's
yeah,
very good.
yeah, good to
Great.
see. Okay, so if I just go to the next slide, as I said, I've just set out here what the plans are for the contributions. So it's the employee, the employer, and the state. For the first 3 years, it's going to be 1.5%, 4 to 6, 3%, year 7 to 9, 4.5%, and 10 plus is 6%. There's already talk, will we actually get to the 6%? There could well be paused, as I've sort of said, but look, very, very early days. This is the current plan of it. And with all these things, there can always be changes. But I suppose the focus for now is the minimum contribution would be 1.5% for both the employee and the employer. Okay, so I'm going to move on now to the Pay Transparency Directive, which again, this is another factor that we're sort of seeing quite a lot of. There's a lot of chat about this, and it's probably scaring people more than we probably needed to scare people, to be honest. It's really an extension of the law that we've had in place for many years, that embeds our Employment Equality Act, and it's to strengthen the application and the principles of equal pay for equal work, or work of equal value, for both men and women. But again, it's bringing in more mechanisms to help ensure this, because we've probably stagnated somewhat in the steps that have been taken. So this is forcing employers to be more active and proactive in terms of sort of remedying this. And obviously this then plays into the legislation that we have had in place with regards to gender pay gap. So the directive will be transposed on the 7th of June next year. But because it is a directive and not a regulation, member states, like ourselves, we have the right to legislate the goals around how we actually implement this. But we have the parameters of what we need to include. So what does this mean first? So pay structures. Firstly, as I said, it's to ensure we have mechanisms in place for equal pay for equal work, or for work of equal value. So we need to sort of look, and this ties in with, you'll see there, the joint pay assessment. And the purpose of the joint pay assessment is to identify, remedy, and to rectify any potential differences that employers might have with regards to pay for men and women with regards to similar work or equal work of equal value. Okay. We need to sort of see how, and I suppose again, so it ties in with the gender pay gap in that, but it goes a step further in that we're allowed to look at categories of workers. So if you take the gender pay gap, we are very sort of stagnated of, okay, how are men paid, how are women paid, and we get the breakdown into the hourly wages, bonuses, etc., etc. But this actually recognizes that you can have people doing equal work or work of equal value. And I suppose to explain the slight difference of that, similar work is quite straightforward. But the equal work is where somebody could have a completely different role, but actually when you get down into the minute detail of the role, they're actually similar. For example, you're looking at sort of working conditions, the level of experience, the skill set, and level of seniority within the organization. It actually is similar work. So there is a slight sort of nuance in the differences, but a very important nuance, and that's how it's covered. So it's very important to, what I would say to clients is, let's do the homework before this comes in June of next year. Let's look at our pay structures. Let's look at the different categories of workers. Whilst it might obviously, be able to sort of say, oh, that person works in that department, so we're able to pay them different, pay them slightly less, for example. But actually, let's go a bit deeper. Is there a genuine reason for that? In terms of qualifications, skills, experience, etc., or is it that they've just been sort of misclassified and unfortunately been paid less? Not intentionally, but in a way it could be perceived that they're being paid less, but for the difference of gender. So as I said, if we do, as part of this audit, see that there's potential issues, there is an obligation under the directive to do this joint pay assessment. And this comes up where the gender pay gap indicates a gap which is at least 5% in any category of workers, has not been justified by objective and gender neutral factors, because as we know, we're allowed to do that, and has not been remedied within the 6 months of the date of the gender pay gap report. Okay. And the employer will have to do this audit and then work with employee representatives from the organisation to show how we're going to remedy this pay gap. Another important factor that has come out of this directive is the information right for employees. So employees have the right to make an information request where they can get the average pay levels broken down by their gender for the employee doing the same work or work of equal value. An employer has 2 months to comply with this obligation. So again, if the employer has done the homework of this and has got this information, they can very readily provide this. So again, it's good homework to have this all in place. The next one, pay transparency for job candidates. This is probably one of the ones that's probably got the most attention out there in terms of what this means. And basically, job vacancies, as we've all heard, have to indicate the pay level or the range for a role. So we have to be more transparent about that. And equally, applicants cannot be asked about their current salary and their pay history. Now, saying that, there's nothing to stop an employer or an employee negotiating salary for the role. So whilst you might put in for example, the pay scale for the job could be between 60 and 65,000, just picking a figure out of midair. But, for some reason, the employer could decide that, okay, we're going to pay this person 68,000. You can still do that, but you need to be able to be sure that you are justified in doing that for objective reasons. And it's not actually because this person is a man or female, for whatever reason. You just need to be more thought process needs to be going in before the final offer is made, rather than just being, oh, we need to get this person, let's just pay them the money. We need to think about it more. And then finally, there's the ban on pay secrecy clauses. This is a somewhat unusual one. I have to say, in my experience, I would see it uncommon that employers would have a clause in the contract to say that an employee cannot discuss their pay, but it is potentially implied from the confidentiality clause that might be in a contract. But I know some employers would, are not keen, maybe is the best way to describe it, on employees, for example, talking about pay increases, etc., and would sort of, try and stress that, when an employee is told that they have received an increase in pay, that they must keep this confidential. This will now be stopped. employees are allowed to speak about it for the purposes of this Pay Transparency Directive. Okay, so what are the consequences of non-compliance with this directive? So firstly, the burden of proof has changed. So with an employment equality claim, the employee is the person who holds the burden of proof, should they bring a claim before the WRC or indeed the Labour Court. Whereas if it's a claim brought under this directive, it will actually be the employer who holds the burden of proof. So similar to an unfair dismissal claim. There's going to be no upper limit on compensation. Now, we'll obviously have to see what the legislation is that Ireland brings in on this, but what the directive is proposing is that the compensation here would be for full recovery of all back pay, including bonuses, payments in kind, any compensation for lost opportunity. I mean, that's something that can be quite hard to quantify, but still potentially there. Non-material damage, interest on arrears, with actually no fixed upper limit on the compensation. It'll be interesting to see what our legislation does on this. It can be a bit of a sort of a dangerous sort of field to go down that. But we do need to be aware that a lot of employers don't actually know it, that an employee can currently actually bring a claim in the circuit court with unlimited compensation for a gender pay claim, and only for a gender pay claim. Any other form of discrimination claim there is the cap as provided, which is the 2 years. Statute of limitations, it's proposing that this would not, we're not talking about the actual date that you would have to bring a claim. This is about the date within which you have to actually bring a claim. So it's being quite distinctive here in saying that the date would only start to run from the date that the employee would actually have reasonably have known. So, you have to bear in mind this discrepancy or disparity may have been in place for quite some time, but the employee has not been made aware of this, either do an audit, the information is coming up, perhaps they've made an information request. There's also a suggestion in the directive that this would potentially go further, and that the time would not necessarily start until the employment arrangement has ended, and or cannot keep going while the infringement is ongoing. So the date would only start once the infringement has been rectified. In terms of comparator, as you'll probably all be aware, if you're to bring a claim under the Employment Equality Act, if an employee is alleged discrimination of any form, they must have a real life comparator. However, the directive is saying that that's okay if we don't have a real life comparator, we can use a hypothetical comparator. That is obviously a much harder case to establish, so we'll have to see how that will come to fruition. But it does potentially make the bringing of a claim of this type easier for an employee, because sometimes for an employee with an equality claim, it can be difficult with the inability to actually identify a comparator. Then we have the penalties and fines. Again, we'll have to actually see how this is legislated, but it is being proposed that they are quite dissuasive penalties, with the suggestion that fines could be based on an employer's gross annual turnover or their total payroll. So it would be something similar to the GDPR fines out there. So what should employers be doing to prepare for this directive coming in? So firstly, as is always with all things employment, review your current policies and procedures. And some of these won't be, policies that are available to employees. These may, in fact, be, internal recruitment procedures, okay, that is available for your recruitment team, HR, whoever it is that's in charge of recruitment, in terms of how we describe a job, in terms of the role, how that, and the salary or even the pay for that. What is the process if we are to go outside of that pay scale? How do we do that? So it's very important to be aware of all of that. Prepare for information requests. As I said, employees can make an information request. So the more we are prepared in terms of, our categories of employees, how we've sort of done our homework, ensuring that there is a suitable and transparent and objective pay structure in place, it would make these types of information requests much easier and quicker to deal with. Again, the categorization of workers, and as I've said, complete an early audit to be prepared and know that we are compliant and we don't necessarily need to set up this pay assessment. Okay, so moving on then to talk about the EU AI Act. Now, I'm not going to spend a lot of time on this. It's quite a complex piece of legislation. And we're sort of in different stages of that. And, this is a very far-reaching piece of legislation, but obviously what I'm focused on today is employment and how that affects employers. It's certainly, I'm sure you're all sort of hearing and seeing and dealing with AI, probably more and more so on a daily basis now, how it comes in. I mean, whether or not you have your own sort of chat GPT mechanism in place, or indeed, if you have procedures around chat GPT, equivalent. But even just on the day-to-day, how much AI can, different sort of computer systems, etc., how it comes into force. So it's very, very important how we deal with it. It's very, very important about that we are alive and aware to it, and we identify the risk factors that are at play depending on the different types of AI systems that you have in place, and the policies that we have around that. So the number one sort of factor that as an employer we need to be aware of is how AI interacts with the Employment Equality Act, because that, as far as we are concerned, is the underlying principles of ensuring that there isn't potential discrimination being applied to employees. Obviously, there is a whole other host of AI factors that we need to be aware of with AI systems, but as I said, for today, we're just focused on employment law. So it's really important to do sort of regular audits on your systems. There needs to be sort of some sort of team and checks and balances there to make sure that you are catching any sort of potential bias that comes with it. It may not be obvious to just one person looking at it, but then you could have, someone else coming in and be like, okay, actually, how that's applying is not correct. And as I said, that comes in with the, the human oversight for that system. We need to be sort of very careful that with the systems that it doesn't potentially breach any sort of common law duty of care to our staff, including any mutual trust and confidence, and that there is a fairness and transparency in all processes. And then sort of finally, as I said, policies and training. You need to be very clear internally what your policy is on AI. If, for example, if you have staff that are training, or even, sort of how are you okay, for example, that they use ChatGPT, for day-to-day work? I mean, we've all sort of seen the newspapers out there, and the sort of commentary on, yes, ChatGPT can be brilliant, but some of the data is not correct, which is hence why we need a sort of check and balances approach to it. So it has its benefits, but it also has its drawbacks. And the only way that we can probably manage that is by having policies in place around, the employer's approach to AI, what that looks like, and then equally to make sure that suitable training is provided to staff around this, so that they are fully aware. There cannot be any sort of debate or argument that they were aware of what they can and cannot use, what the purpose of the AI is for, and to ensure that everybody knows, for example, that, if they do see a flaw in the system, or that there is some potential issue with it, how it can be reported and identified and rectified effectively. Okay, so moving on to gender pay gap. So obviously we've had the Gender Pay Gap Information Act that has been in place for quite some years, and we are finally at the final stage of that, which meant that from the 1st of January of this year, any employers with headcount 50 or more are now obligated to do the gender pay gap. So how that works is a snapshot date has to be picked, should have been picked in June of this year, and then you have a reporting deadline of 5 months from that date, which means that reporting will be taking place in November of this year, and that will be dependent on the date that you have picked in June, of what date that will be in November. Your reporting period is 12 months from that snapshot date in June. And I've just set out here, I'm not going to sort of read them out, but what that looks like in terms of the various different calculations that need to be provided. But probably what I would say is the most important piece is the employer statement around the gender pay gap, and why there might be a pay gap, how that has been identified, and any sort of steps that are going to be taken by the employer in order to rectify that. It's very important to remember that you're not going to get in trouble because you have a gender pay gap. The majority of organizations unfortunately do have it. But what is important is, how you explain it and what you're going to do, what your steps are to do to rectify this. And this is where it ties in again with the Pay and Transparency Directive. A lot of employers have actually sort of, already done gender pay gap reporting, even before they came within, the requirement of the minimum of 50 people. So you may well and truly be sort of versed in this and in it, or just may indeed be your first year of doing it. But certainly it's a very good exercise to get into, and certainly helps with the Pay Transparency Directive that will be coming into force next year. So another sort of interesting piece of legislation may or not apply to anyone on this call today, but it's useful just to show the way that the government is thinking. And again, a step further about dealing with the gender pay gap, but taking it to dealing with sort of boards, non-executive directors and executive directors. So this came into effect at the end of May of this year, but only applies to listed companies. And it's basically that it provides that by the 30th of June next year, listed companies must either have 40% of their non-executive directors be held by members of the underrepresented sex, or at least 33% of their director positions, whether it be executive or non-executive, be held by the underrepresented sex. So again, it's this sort of move that we're hearing, that boards are severely unrepresented, and that they tend to predominantly be male. But don't get me wrong, I'm on a board where it's predominantly female, so it does go both ways. And this sort of sets out the steps and the processes that listed companies will have to do. So on the 30th of November each year, they're going to have to report on this to the minister. So setting out, what the gender representation is in place, if there is a gap, how they're going to deal with that and rectify it going forward, and what their objectives are. Okay, so next we have the Maternity Protection, Employment Equality and Preservation of Certain Records Act. Bit of a mouthful. So I suppose the two big important points to have about this was, firstly, employees who are unwell. For example, somebody who might find out that they have cancer, unfortunately, during maternity leave, they are now able to pause the maternity leave due to the serious health conditions. So they would be on sick, go through whatever treatment they need to have, and then take that maternity leave then at the end of that period. Unfortunately, until we had this legislation, a lot of mothers were sort of effectively missing out on that time with their child. So very, very important and very relevant legislation. It also provides that members of the House of the Oireachtas will be able to take maternity leave. And then the other piece, which I think as practitioners, we all thought we were going to see a lot more about this, but has actually been relatively quiet, not quite sure. But this is this mechanism around the non-disclosure agreements. And it basically says that they're prohibited where you have cases of discrimination, harassment, and victimizations, where the purpose of that NDA is to conceal the information regarding the allegation, unless the employee makes the request that they want to enter into such an agreement, and the employer will contribute reasonable costs and expenses for that independent legal advice. In my experience to date, there hasn't really been any sort of difficult conversations, where this has arisen. The employee has sort of said that they'd like to do a deal, they'd like to sort of move on. And, generally speaking, some sort of contribution to costs has been made. We'll have to see, the case law that's potentially going to come out of this, pushing how much is reasonable legal costs. But I certainly have not seen any sort of dramatic increase in a contribution for legal costs in agreements of this type. So what does this mean for employers? What do we need to do? Obviously, you need to adopt your policies and be aware for this piece with regards to maternity leave being postponed. And then just ensure that with regards to sort of any type of discrimination, harassment type case, that employees are aware of their rights here, but also their right that they can still enter into an agreement, and how they might go about that. So in a way, it probably is making the issue more live in an employee's mind, and they might feel more confident to be asking for that sort of support. It's always a tricky conversation. It can be quite difficult. We need to be very conscious of it, particularly with regards to sort of the lack of without prejudice conversations when it's not lawyer to lawyer. But certainly, it hasn't sort of created as much of a difficulty, I would say, on a practical basis as we thought it might do. Okay, so important case law development. So there's just a few cases here I want to talk about. This first case, you may or may not have seen it in the papers. It was about a freelance photographer for RTE, who did photography for Fair City. And essentially she was let go in December 23, if I recall correctly off the top of my mind. And she brought an unfair dismissal claim. She said, essentially, whilst I was categorized as a freelancer, I was in fact an employee. And she brought a multitude of claims, including a working time claim, terms of employment information claim, payment of wages, and then ultimately an unfair dismissal claim. So there had to be a sort of a preliminary hearing on this because RTE were claiming that she was freelance worker, so i.e. she was a contractor, so she didn't have the jurisdiction to bring this claim before the WRC. And obviously her legal team were saying that she was an employee. And she was ultimately successful in the WRC, where they applied the five-step test, for the Carson case, which we'll all have heard about. This was essentially the domino Supreme Court case, which has now set out the test essentially for determining whether somebody is an employee or contractor. And the WRC there looked at the remuneration, the service, the control, her factual terms, and of course the relevant legislation. But it was very clear by all the certain terms she was devoted to the RT. I think she had the ability to work outside of the RT for any other organisation for a couple of hours per week. So, sort of 95% of her time was focused to RTE. She was answerable to them. Her salary was sort of dictated by them. So in reality, the relationship had gone on for so long that really everything pointed to her being an employee. And I suppose what I actually just like to flag, and I haven't put in the notes here, is a bit of a sort of, there's been a further direction note issued by Revenue. Now, I'm in no way a tax advisor, but what that has said about is this sort of no man's land that has been brought about from this Carson case. A lot of employers are, sort of doing their own audit now to establish, are people actually employees or are they contractors? And effectively, what the Revenue has issued is they're giving employers, the ability to sort of nearly put your hands up to say, okay, this person actually should have been classified as an employee. You're describing it, I think it's some sort of error. You describe it as through the system, and as long as you sort of pay the tax for that, there will be no penalties or interest payable. However, if after this date, you've classified someone as a contractor and they were in fact an employee, then they will probably be quite ruthless, I would imagine, with the sort of the penalties and fines. And I think we'll probably see a lot of inspections probably coming from this in terms of Revenue trying to crack down even further on this issue. Okay, the next case is just a useful one to be aware of in terms of policies around acceptable uses policies, for example, devices, phones, laptops, etc. This employee had their phone hacked, their work phone hacked as part of the HSE hack back in 2021. He had personal email and cryptocurrency account on his personal work phone. And he tried to sort of say that his employer was liable for it. He initially brought a complaint to the DPC. They didn't find it in his favour, so he brought a judicial review case to the High Court. The employee in this case did accept that there was an acceptable uses policy, and it was very clear that personal use of the work phone was prohibited. So the fact that he had accepted that, and the fact that there was a very clear policy on this, found that the HSE was not liable for the hack and the effect that this has had on his leakage of personal data with regards to his personal email account and cryptocurrency. So this is a classic case of showing how important it is to have a policy around this type of, for example, use of phones, laptops, etc., what it is and is not permitted to do. Okay, so this case, you may or may not have heard of it, was a very sizable award. In the end, the person got €445,440 awarded by the Labour Court. He was an Irish founder of this company. He was based over in Boston, I believe. And he was ultimately dismissed by the organisation. It came down to a dispute he had with the group CEO over equity, etc. And no process was followed. He was just ultimately dismissed. And when it came to the WRC hearing, the employer admitted that he was unfairly dismissed. So the issue then was a matter of quantum, what he should be awarded. As you'll probably all be aware, with an unfair dismissal claim, an employee has a positive obligation to mitigate their loss. and they can be cross-examined on that, and potentially any award can be reduced potentially if they have not adequately mitigated their losses. In this case here, the employer said that he hadn't properly mitigated, because that he'd only incurred minimum wages. So essentially, he was bound by a 12-month non-compete clause, which significantly restricted him. He had set up an entirely new company, but he'd only earned, I think he had earned less than maybe 15,000. It could be even less in that time period. And they tried to say that he didn't take significant steps. Whereas the WRC and indeed the Labour Court on appeal said that he had done what was sensible. He was in quite a unique position. He was a very senior employee. He was restricted by this 12-month non-compete clause, and he had done what he could in the circumstances. So they felt that the amount of what essentially equated to 16 months was just and equitable in the circumstances. And effectively, this is one of the highest awards that we have seen by the WRC and indeed the Labour Court. So again, I suppose obviously we couldn't have predicted the mitigation point, but it comes down to the need to follow a fair process in terms of any sort of dismissal. Okay, so my last case here is just a mandatory retirement age. This comes up a lot. What I would say to you, so obviously you can have a mandatory retirement age in your employment contract, but it's not enforceable unless you have a retirement age policy, which provides an objective justification for that retirement age. It is so, so, so important. I can't stress it enough. If you don't have the two together, you're not going to be able to enforce the retirement age. In this case, the Royal College of Surgeons did have an objective retirement policy, and this lady in particular, she knew that it existed. So upon reaching her 65th birthday, she asked could she be kept on for longer, and they agreed to keep her on a one-year fixed-term contract for business need. This is allowed, it's permitted on the Acts. You have to have the objective justification for doing it. When she was on that contract, she then learned that colleagues were being kept on past the age of 66, and she felt that she was being discriminated against. However, she was unsuccessful in her claim because the respondent was able to show that once there was people kept on past the age of 66, they were unique and they had their own objective justification, which was entirely different to this lady's role. These people held like technical and academic roles, and they would be, very difficult to replace. So they were justified in keeping them past the age of 66 until they were able to find suitable people to fulfill the roles. So again, so important that we have the retirement clause, but also the policy to justify it. And equally, if you are letting anyone work past your retirement age, that you do so in line with your policy, that you put them on a fixed term contract, and each fixed term contract must have an objective justification for renewing it. Very, very important. Okay, so last topic, as I said, the WRC annual report. Just want to touch on this very briefly. It can give a very good insight of sort of the trends of what's been happening. This was obviously for 2024, but just shows what's going on. So we saw an 18% increase in complaints regarding pay, unfair dismissal, and discrimination last year. An 85% success rate for the conciliation service. So a lot of this will come down to the mediation service that you may or may not have been aware of, party to, etc., when receiving a complaint to the WRC. So it is being very much used. We obviously saw the introduction of the code of practice on remote and flexible working that was long awaited, with the digitization of the WRC e-complaint form. But I thought the last point was what's most interesting. This is workplace inspections. You may or may not have experienced one. They're quite a stressful thing. But my experience of them, if even if you're not fully compliant, if you work with them and it's not an extremely serious breach, you will come through it on the other side. So this shows that they have a particular focus in the construction, food and beverage services, hotels, hair and beauty, and retail sector. And overall, they're saying the majority of them were in compliance and some became compliant, as I said, through the inspection. There was 5,156 of these carried out in 2024, with 2,180 of these failing to comply with the employment law obligations. So like less than half of them, and 2.15 million recovered in unpaid wages, which is no small change. So that's the end of my presentation today. I'm sure there are lots of questions, but we do have this one last poll that you might all just take a look at and give your thoughts on.
Great. So the results are in. How often do you provide training to your staff and current updated employment policies annually when they start employment or never? It's quite balanced there. Um, so that's very interesting. And thank you very much, Bláthnaid, for all these great insights and practical tips that all the audience can bring back to their organization today. We received a lot of questions while you were covering all these topics, so we'll try to assist as many as we can. So we received some in the chat and in the Q&A function. Do you want to have a look there, Bláthnaid? I think the first ones cover the pension and the retirement. Do you want to have a look there and see if you want to cover some?
Yeah, okay, yeah, we'll try and cover as much of these we can.
Yeah.
So are deductions for auto-enrolment due to begin from the start of January? Yes. So it's starting from the 1st of January next year. So the point is that you will be getting, as I said, they're going to be getting in touch with employers from early to mid-December, with it basically taking effect from the 1st of January. So what might happen, it might be prorated for the first month, depending on when your pay date is. But yes, it will be taking effect from January. So next one, can someone 18 plus and under 23 still participate? In this case, do they need to approach the employer? So it's anyone, let me just double check my notes there. It's anyone over the age of 20, but equally, if you want to participate in a pension, absolutely, you just get in contact with your employer. There's no problem whatsoever on that. Sorry, it is 23. Sorry, it's 20 for something else. So they're just not automatically captured by it. But if somebody wants to join, and you should always give employees anyway the option of the fact that you have a pension scheme there available to them. Okay, in relation to pension schemes, can you make it mandatory for employees to join the company pension scheme and join in the company? I know you can't introduce this for existing contracts, but is it allowed to make it mandatory for new contracts? Essentially, yes, for new contracts, because it'll form part of the auto enrolment. So, what you would need to look at doing is updating your contracts for new hires to say, as part of the pension auto enrolment scheme, you will join the scheme on your first day of employment, but you will have the right to opt out of this on once the 6 months have passed. Okay, we have a company pension scheme, 1 year of service. We have a company pension scheme in place from 1 year of service of 6%, where we do not require employees to contribute. Can we automatically enter those eligible into this scheme at 1.5% until they reach 1 year, and then raise them to 6%? Do we need their authorization when we are not requiring them to contribute, or can we make this a term of their employment so as not to enter into a dual scheme? So part of this you'll have to check with your pension provider and what you can do within the scheme. Okay, so if you can have, I presume you can, right? But it's always subject to the rules of the scheme, that you can have different sort of contributions, for different levels of employees. What you're saying principally, I don't particularly have an issue of it. The only thing you need to be careful of in that case is a potential discrimination angle, and that would more so come in, for example, like with a fixed term worker. Okay, so if this was applying, I'm saying it's unlikely, but for example, if your staff that were at this stage were, a majority of them were for fixed term workers and they were being treated slightly differently, you could have someone saying that they were being treated differently for that reason. But so long as you're being consistent across the board, and that is a condition of the employment, then you're compliant with the legislation. So I don't see that being an issue.
There are actually some questions still about the pension in the chat as well, Bláthnaid. So one is, how should companies inform staff about the auto-enrolment?
So the best way is probably sort of a type of town hall meeting in the first instance, right? Is get people together, explain to them what it involves, and explain to them what is the current setup. Like, do you have a pension scheme in place? What is it you're proposing that you want to do? Just be transparent and upfront with them, and then probably follow up in writing to them, depending on what the plan is. Are you giving them the option to do, do you want to have two schemes running? Or are you going to just have one scheme? So it's the best way is a sort of, as I said, a town hall, and allow employees to ask questions. Even have a Q&A like document prepared in advance, that you can share with people, and then follow up obviously then in writing after that.
Cool. And can you make it mandatory to join employer pension scheme for future employees, not auto-enrolment government one?
Yeah, so it's the same thing really. So when we say auto-enrolment, it's auto-enrolment to a scheme. So if the employer has a scheme in place, it will be mandatory enrolment into that. Bearing in mind, you'll always have to provide the employee with the option to opt out after 6 months.
Okay, so there's a question from Quiva here. It's not mandatory. You can't make employee join your company pension rather than the auto enrollment, right? You can't force them. They can opt out after 6 months.
After 6 months, yeah.
And there's a question from Lorna there. When do pension contributions have to be evidenced on pay slips for employees to not be auto-enrolled? Is this from the 1st of January or in the look back period 13 weeks before?
It applies in the 1st of January, so it'll be from the payslip in the 1st of January. You just have the look back period to see who is eligible for the pension.
Okay, very good. And last question about the pension there, about the auto-enrollment. In terms of getting people onto private pension scheme, if they don't want to move over to that one, is the only option auto-enrollment in January, or can we automatically move them to the private scheme?
So, it's a good question. So, again, this is where the conversation is really useful. Okay, so the default is if you have a company pension scheme and let's say 20% of your staff aren't on it, they will automatically be enrolled in the government scheme. But if you want them to join your company scheme, then you need to get them to consent to that. So this is where it's really important to sort of have the conversation with them, explain to them, look, the default is going to join this scheme, but actually we have this much more favorable scheme. And if you join that, you're going to get a better contribution, for example. So it's about the sell and for them to understand this.
Great. So I think we're done with pension questions and we're back into the Q&A function there. Bláthnaid, if you want to take Tara's question, is there any exemptions expected for small employers for pay transparency, perhaps similar to gender pay gap reporting?
That's sort of been left to the member states. So we're going to have to see how that's going to potentially operate. But I wouldn't be surprised if there's a similar approach taken to as there has been with gender pay gap. Yeah.
Okay. And we had a similar question in the chat from Marina, actually. Does the Pay Transparency Directive apply for companies with less than 50 employees? Yeah.
Yeah. So we have to wait and see that. Yeah.
Cool. Is there software you would recommend to complete the analysis for the Pay Transparency Directive? We have a job architecture structure in place.
So unfortunately, no, I don't have any recommendations on this. I know a lot of I presume there's a lot of companies out there that have helped with the gender pay gap. Even a lot of the accountancy firms I know have helped manage this. So, I would probably get in touch with your accountancy practice, your firm that you would use, and they should certainly have recommendations in this space. But I personally don't have anyone. Apologies.
Okay. If the pay gap is negative, as in female are paid higher, is there an issue?
There's not an issue as long as you show your steps and you're proactive in how you rectify it. It's okay to have a gender pay gap. This is the point. It's about, okay, let's see what the problem is. How are we going to do it? How are we going to rectify it? And as I said, you have this joint pay assessment audit. And that only has to be set up when there's been a pay gap identified. It affects more than 5% of the staff. You've 6 months to rectify and remedy that, right? Or at least show steps on how you're going to do it. You might not be able to fix it in 6 months. I appreciate that. But if you don't do that, then you get into this next step of an audit. And I know there's been a question there about what if you don't have employee representatives? And that's fine if you don't. A lot of organizations don't have representatives, but you ask the workforce, you go through a process of electing who those representatives would be. So it's set up for the purpose of this. So again, it's a bit more of a headache. It's sort of paperwork, etc. So that's why we're encouraging employers to do these audits now and to try and get ahead of the game before the legislation comes in place next year.
Okay. And we have a question from Neve actually on that. Do you have to have a pay band range for each category, or can you have an actual salary?
You would probably have a range.
Yeah,
It wouldn't be accurate to have a salary because there's always going to be factors that come into that. So, but it would be a tight enough range, and so long as you can justify the range, yeah.
cool. And Meave has a question around that kind of headcount size. Has there been any change in the headcount size for SMEs? We're under 24 in Republic of Ireland, 62 in the UK. Are we obliged to complete the report in 2026? And what key pay transparency directive points discussed will affect our company?
Well, again, I suppose the headcount point is what we've previously discussed. And sorry, what was the other part of the question? Sorry, I can't see it here
Sorry, yeah,
actually.
and because of that size category, what is the effect on their company? I think you
Um,
assessed that during your presentation. So if Meave wants to have a look at the recording there, I think you assess all the different size category. Great.
yeah,
We have a question in the Q&A from Mick. Equal pay audit. What if there is no EE representatives?
yeah. So I just touched on that one. So, if you don't have representatives, that's fine, but you would have to go through a process of electing them, which would probably be done by secret ballots. And as I said, it's a bit of a headache to do it by all means, totally. And again, it's why we recommend doing the audit to try and have to avoid that extra bit of paperwork.
Good. And we talked about that kind of pay on vacancies. Sinead is asking if there is any exemptions, especially, for example, for executive level positions.
No,
No.
currently not. I mean, we have to see, as I said, like this is the directive. We'll have to see what the legislation says, but currently this is applying at all levels. And I think that's where it's going to get quite delicate in organizations for sure.
Cool. We have a question again from Mick asking, I know at a certain point you were saying that as an employee we can make a request to have the price range, etc. Mick is asking, can a union make an information request?
Yeah, that's a good question. So firstly, I would say you would have to recognise a trade union. If you don't recognise a trade union, absolutely not. If you do recognise trade unions, it would need to be done. Potentially, it could be done. I would say I don't think you could rule it out. Um, uh, but again, it's the legislation. Well, sorry, the directive is currently silent on that. Yeah, but yeah, I think it would depend on circumstances.
Okay. Another question from Sinead, is the government central portal for publishing the gender pay gap live yet?
I believe it is. Yeah, I believe it has gone live. Yeah, yeah.
Can start now. Very good. Another question, can employees be paid more due to length of service for the same role?
Can employees be paid more?
Due to length of
Oh,
service.
sorry, this is in terms of sort of
Yeah,
salaries
this
and
is
stuff.
back to, yeah, this
Yeah, yeah,
is
potentially. I mean, this could be a factor that comes into it with regards to, and again, it's why we would have a salary range, as opposed to a fixed salary. So you would have sort of, points of that to justify, for like if the salary range was say between 50 to 55,000 per annum, you might say somebody who has, a number of factors, including, for example, 10 plus years service or something would be at 55. Yeah, so absolutely.
We'll take just a couple more questions in before we wrap up. So one is about the maternity protection update. How is the NDA tying into the maternity protection update?
So this was just a bit of a catch-all piece of legislation that sort of dealt with a number of different factors, right? So we had the maternity protection update houses of the Oireachtas and people who had long-term illness. And entirely separate to that is the NDAs, but this comes into with, discrimination, victimization, and harassment cases. So it's entirely separate to the maternity protection changes, but it's just been all housed in this one piece of legislation as a catch-all.
Very good. Last question for you, Bláthnaid. How soon after the legislation is passed do employers have to become compliant? That's a question from Debbie in the chat.
I presume this is the pay
I
transparency.
think so. Yeah, I think that's what we were
Yeah,
discussing. That's when
okay, yeah. So, well, I suppose it'll come into effect straight away, right? So this is why we're sort of being given this notice on it. But again, there'll probably be something in the legislation that's implemented to sort of say, employers must be a bit like the gender pay gap. You do your audit, you pick your date in June, you do your audit in November. There'll probably be some period in that. So again, we're just going to have to wait and see what that looks like. But I'd be sort of preparing on the basis that it has to come in by June. So we need to be, as prepared and as ahead of this as we can be.
Very good. And with this webinar, we can be more ahead of everything we need to cover as employers there. So yeah, navigating these changes can be tricky enough, but keeping ourselves informed is half the battle, right? So thanks everyone for joining today. Thanks a million, Bláthnaid, for all these great tips. And yeah, thanks everyone. Have a lovely day. And thanks again, Bláthnaid.
Thanks, Millie. Thanks very much.
Bye everyone. Take care.